Continue to inspire us. Continue to help us towards making the right decision. Progressive steps towards prosperity, towards the well-being of your people. Father, whatever it is that we have decided to do, let it be because of your will and your way. Let Jamaica be a model in the Caribbean. Father, we are dealing with topics that are new, topics that are sensitive. Father, enable us to take the right approach. Enable us to always put the people first. We trust you. We depend on you. And help us to always listen to your voice only. These and other mercies we ask in your name. Amen.
Thank you. Apologies for absence. Apologies for absence. Mrs. Vaz? Okay, noted. Mrs. Anne-Marie Vaz. Members, colleagues, let me utilize this opportunity to welcome you back to this our joint select committee sitting on the sexual harassment bill. Over the last 3 months, we did not have the benefit of meeting regularly as we had intended due to intervening circumstances. However, we remained resolute that as soon as we could, we would meet. And our gathering today is a testament to our resolve to the people of Jamaica that we will afford them access to a comprehensive legislation aimed at rooting out the societal dysfunction that is sexual harassment. I really want to thank members for turning out in their numbers today. There is much to accomplish. Welcome, Minister Chuck. There is much to accomplish, and I know collectively we can achieve it. By returning to our regularly scheduled meetings, we can ensure that the Jamaican populace has an operational legislation before the end of the fiscal year. Let us, with renewed efforts, work to make this a reality. At our very last meeting, we were all agreed that a public sensitization campaign be done on the bill so that the public could be more informed about the offerings of the proposed legislation. By the way of update, I wish for it to be noted that the sensitization campaign will be launched shortly and will take the form of both print and video. On our agenda today, we will have 2 presentations, one from Mr. Douglas Siraton and the other from the Jamaican Network of Seropositives. Just 2 we have, right? We had the JCC scheduled, but unfortunately they can't make it today. So let me thank you all for giving of yourselves to be here, particularly to the technical team to my left. Thank you for coming. And I look forward to all the varying contributions. At this time, we will take the minutes. I don't know if you have all had a chance to read the minutes and if there are any corrections. If not, I ask for the confirmation. Were these minutes circulated in advance? Or just yesterday? Yesterday. Okay.
May I?
Yes. Member Daly,
yes.
we really are happy. We're happy to see your face.
Yes.
Thank
you. Thank you, Chair. First of all, let me say that I'm happy to start my participation in this very important Joint Select Committee, and looking forward to us concluding the examination of the bill and to produce something for the Parliament and for Jamaica that is worthy of our work. Thank you, Chair, for pushing this to the point where the bill was tabled. Having just seen the minutes, I would recommend that you give us a chance. We forego it for now, that's my recommendation, and we go into the presentations unless members might have anything burning from the minutes, but I think we didn't have a chance to read them, and maybe at the next meeting we can take all the minutes. That's my suggestion to you, Chair.
Your suggestion is accepted. So we will move on from the reading and matters arising, reading confirmation and matters arising, and we will take the presentations. And so at this time, I invite Mr. Seratan to make his presentation.
Thank you, Madam Chairperson, and thanks for the invitation to share my humble opinion of the bill. I have prepared a statement, so I'll just read from it. Excuse the crackling of my voice as the butterflies exit my stomach. Section 3, subsection 2, duty to ensure an environment free of sexual harassment. The provision of this section does not extend far enough to ensure the protection of patrons and staff from other patrons of a business establishment from sexual harassment. In a society where employers still feel that customers are always right and where employers are slow to adapt modern standards, it is incumbent on this committee to ensure that employers know that they have a duty of care to their patrons and staff and empower them first to take reasonable steps to ensure the protection of the occupiers of their property, and then to act when cases of sexual harassment are reported and investigated and found to have merit, and make them accountable for this. Within recent events taking place in the United States of America, wherein women have sought justice against men they have considered to be powerful in their respective fields, they have sought justice against these men who they claim to have been sexually harassed by these men. The hashtag #MeToo movement. While the fact that these women have received justice in some cases is commendable, however, it is arguable that in some cases have emerged wherein this movement have become a weapon to be used against men in powerful positions that women in the past have felt that they may not have gotten the benefits that they have wanted. And most persons can attest to what they might consider in offices the V-power was not effective enough. The fact that these men have become victims, sorry, let me go back. So the fact that these men have been accused falsely and have become victims without a fair trial in the public domain, and so we must ensure that this act is not able to be weaponized, to use as a weapon to solicit or to exact revenge. What I seek from this committee is that you seek to protect those amongst us who may become victims of these false, malicious, or ill-conceived accusations. Hence, the weaponization of this act to kill, damage, or scar the reputation or career of a person or persons whom they have in the past or present find discontent with someone and seek to have their revenge. So I'm imploring this committee to protect each and every citizen of this country. It must also be noted that the perception of an action or inaction by one person does not in any way, shape, or form dictate or define the action or inaction of that person. The perception of one person does not dictate the action of another person. So, a sexual harassment suit or claim can be brought against somebody because of what their perception is of what an action was. Section 31 of this act seems to be a poor compromise that does not go anywhere far enough to prevent the weaponization of this act. Section 31 deals with false accusations. It seemingly implies that after one's reputation is damaged and scarred or murdered, that the victim will then need to appeal to the tribunal, as indicated in the act, or some court of law to adjudge against the accusation levied against them, and then to get justice from the imposition of this fine. What I seek from this committee is to first ensure that when the accusation is first levied in the office or workplace or in that small space where the accusations are levied and that reputation can become scarred or damaged, that if investigation proves that there's a duty of care, that a proper and full investigation is held, and if the accusation is found to be false or ill-conceived or ill-perceived, that the employer can take action against those who can make those false accusations. And that's it.
Thank you for your presentation. I know Ms. Grant, legal officer from the ministry, wanted to make a comment.
Yes, Madam Chair, I was just pointing out that the section that was made reference to, the false complaint section as section 31, it's actually clause 39.
Could you just say your name for the purpose of...
Oh, I'm so sorry.
Yes.
Georgette Grant, legal officer from the Ministry of Culture, Gender, Entertainment and Sports. So I'm just pointing out, Madam Chair, that clause 39 is what is to be properly referred to and not 31. It could be that at the time he was reading from an earlier version, but that is not so. And as it relates to false complaint, I'm looking on what was submitted to us prior to our sitting here. And the second point, with recent events in the global economy, we must take a duty of care to also protect people from false accusations and make it a criminal offense. And clause 39 addresses false complaints and says that where it is found that anybody who contravenes subsection 1, which speaks to the making of false complaint, commits an offense and is triable summarily in the parish court. So I want to know, because I'm not sure Mr. Seraton had access to this version, so I want to know if that is still a concern.
So Seraton?
Yes, it is still a concern, because here what? By the time it gets to the parish court level, that reputation, that person would have already lost their job, his reputation would have already been scarred. So what we're trying to do is what I'm seeking to do is to ensure that at the initial level, at the ground level where the accusation is levied against an individual, that individual then has a protection under the law to ensure that his livelihood, his reputation is not dragged through the gutters and then, or her, right? is not dragged, that person's reputation is not dragged through the gutters until it reaches the parish court where he gets justice. So if a duty of care is levied on the employer before it gets to that level, because persons have languished in waiting on justice to be served, and justice delayed is justice not served. There's a recent case of teachers who have been out of their jobs for 4 years awaiting justice. Or parish courts are clogged with cases while this person is without an income. This person is family suffering. So what we can do is look at ensuring that before it gets to the level where this person has lost their job, there's a duty of care on the employer or manager or the proprietor of the business to ensure that a proper investigation is done and justice is swift. Thank you.
Yeah,
It seems to me that
Member Chuck.
even in the case, I don't know the case you mentioned about the teacher, it could be a sexual harassment case. Let's call it a hypothetical case.
No, it was a real case, but it was maybe that she had a...
No, all right, we don't want to get there. But it seemed to me that this bill is, in a sense, to assist cases like those, that it can be dealt with in a quasi-judicial tribunal. In other words, what I mean is that this bill, where there's an allegation of sexual harassment, which basically doesn't amount so far to a criminal offense, where there's a sexual assault, for example, then the tribunal has the opportunity to deal with it outside the purview of a court system. You're with me? So that, in a sense, this bill should be supported by you if indeed it's just a question of an harassment claim rather than a criminal abuse, if you get me. So are you in support of the bill?
I'm in full support of the bill, but as I mentioned earlier, for it to get to the tribunal or the parish court, time has elapsed.
No, but what we're saying is that once a claim of harassment, then one would hope that a tribunal which could sit in several panels, okay, that is what is intended, that it can be dealt with in matter of days or weeks. No, it's a different matter if it is a charge where a person is charged and with a criminal offense and it goes to a parish court, and that is where I'm not denying it takes an unduly long time. But this bill is not anticipating that the matters are going to a parish court. This bill is anticipating that they're going to be dealt with by panels. You get me? Panels which would be in the ministry. So once the complaint is made to the ministry would set up a tribunal and the matters are dealt with. You get me?
If I may, Chair.
Mrs. Robinson, could you just say your name and just for the purpose of the...
Okay. Sharon Coburn Robinson, Bureau of Gender Affairs. Should I be speaking? Right. I wanted to point out to the person who made the presentation that in terms of the responsibility of the employer, it is very clear in Section 3. It details the responsibilities that the employer has. One is that the employer should, and I'm reading from Section 3, Subsection 1, an employer shall make every reasonable effort to ensure that the employers employed by the employer are not sexually harassed in the course of their employment. 2, Subsection 2, a person who is in charge of an institution shall make every reasonable effort to ensure that the students, residents, wards, inmates, patients, or members, as the case may be, of that institution are not sexually harassed. And it details what is required in terms of making sure that there is a written policy statement. There is and the statement is brought to the attention of all persons within the institution or within the organization, and that the person who is an employer should take such steps that are reasonably required to bring whatever statement is noted and whatever statement is agreed on to all persons who would be a part of that space. That definition of sexual harassment, which is consistent with the provisions of the Act, a statement to the effect that workers, students, and all other members are entitled to an environment that is free of sexual harassment. And that statement is designed to ensure that the disciplinary measures that are appropriate may be taken against any person under the direction of the employer or the person in charge of the institution who subjects any worker, student, resident, ward, patient, as the case may be, to sexual harassment. And the internal mechanisms and procedures should be available to all persons and should be noted that all persons are able to access methods of redress. So there is a duty of care in terms of the employer and the responsibility, and to make sure that all persons within the space are aware of what it is, a written workplace policy and something that allows all internal mechanisms to be known by all persons within the organization.
If I may, Chair.
Chair, can I?
Yes, member. Yes, go ahead, Senator.
I just want to seek some clarity from Mr. Siratan in terms of his first bullet point, where he's talking about or suggesting the responsibility of the organization to protect against sexual harassment. In this case, you have sought to indicate the protection of the employee against the employer and maybe a customer maybe a customer against an employee. But you have cited in this case where a customer may be harassing another customer. In this case, how would you suggest to this committee that be treated in terms of the accountability? Because in the first two instances, I can assume and appreciate where the employer would be protecting the employee against another employee, or the employer against the employee, or a customer against the employee. But you have cited where you're asking the accountability to rest where a customer may be harassing another customer. Let's assume in the banking line where you may be a customer and one customer may be harassing another customer. In this case, what would you be suggesting to the committee in terms of who will be held accountable?
I could go one up to, let me give you another example. Two patrons on a bus. And this is something I have commonly heard. One person rubbing their genitals against the shoulder of another person on a public transportation. So, what this committee can do is empower the employer or the proprietor of that space to maybe ban that customer from that space for a period of time, or from that building for a period of time.
you're suggesting to us that we have to, because the concept of this piece of legislation was to, in scope, treat with the workplace or an institution. You're suggesting to widen the scope.
Yes, sir.
Member Daly and then Senator Longmore.
Chair, firstly, I would like to thank Mr. Sheraton for appearing and giving his comments. I think the committee appreciates any organization, individual that take the time to come and make a comment on a bill that will be passed. And I listened carefully to him and to the explanation from legal officer from the ministry about section 39. What I want to ask, if you have the new 39, you have it, okay. Because I am of the view that 39 covers the issue of false complaints quite adequately, in my view. But you have introduced two things. You introduce, in a way, false complaint when you cited prominent, powerful persons making claim, sometimes months and years after, like you cited the United States, and we all are aware of those cases. Several persons coming out of the Me Too movement who have come forward, and some were proven to be correct. Okay. So if someone made a false complaint or a false accusation, there's a penalty for that. And I think we are satisfied that the bill covers that penalty of false accusation. Okay. You move to another point where a public company, for example, or a bus from Port Antonio, I'm a practical man, very practical, coming into Kingston every morning, and there is a particular passenger who makes it a habit to do the things as you described on other passengers or passenger coming in. You are saying, if I understand you correctly, you're saying that we must make provision to protect that passenger from that harassment in the bill. I just want to make sure that I understand what you're saying. That if it's a public company like the JUTC bus, a complaint is lodged by a passenger who travels regularly on a route. If that complaint is lodged on more than one occasion, or lodged at all about this person, that the JUTC must find that person who is doing what you described and ban the person, or it is the duty of the person to lodge a complaint about this person who she might never know the name of the person, but see him each morning coming to take the bus. I want to be sure what you're asking, if you can help us.
All right. It is not for the JUTC to go and find this person, but it is for the JUTC to be accountable for the passenger who is harassed. So if a female comes and says, this man did this to me, they may be able to review. I know the JUTC has cameras on the bus. They may be able to review, put a picture of the man on the bus and says he's not, or circulate a picture of the man and says, look, this man is not supposed to take the JUTC. If it is proven that his actions wasn't just a one-off thing, maybe an ill-perceived action, but is something that has been reported by maybe numerous persons. So then the JUTC can take action to say, well, here what? I'm going to protect the passengers on the bus, my other passengers, and this person is no longer welcome on this bus. This person can find, this person has given up his right or her right to ride this bus. That's what I'm saying.
I want to make sure I understand it is very difficult, but I just want to make sure that I understood what you were saying.
Excuse me. But we need to put the duty of care on the JUTC to act. Not just to say, take the complaint, but to act on the complaint. Because words on a paper, words, accusations don't do anything. We need to empower them we need to first empower them to act and hold them accountable to the action.
No, but Mr. Serraton, we have to use some common sense in limiting how far a person can go to enforce any rules or regulations. Within the workplace, I understand. You get me? If an employer knows that an employee is regularly harassing another employee or harassing customers who come in, the employer admittedly should be as a duty to take care. The same with a school, maybe a church, and where there is some authority on the person who has a duty of care and can take responsibility and can act. But when you come to a bus, to say that a bus driver or the conductor must take responsibility for a passenger, or the owner of that's a difficult one to ask the legislation to reach out, because you see, it would be the same, and you might even go further along that tangent to say, if in fact, when employee walk through Grand Spend, which is my community, there are particular boys who are harassing girls who work at a certain workplace. What is the MP doing about it? You see, and how far do you go? You see the point I'm making? So what we're really saying, there has to be some line where, and that is why in this act it looks at the workplace. It looks at the workplace. Because even in a bar, for example, to say in a bar or a nightclub that customers are harassing one another, and there's one particular customer who is always looking out for the ladies and harassing them, an harasser. I mean, are you saying that in that situation, the owner of the bar has a duty to stop that person from coming in? It's a difficulty. You see the point I'm trying to get at? How far do you go to say that the owner of an establishment, the owner of a motor vehicle, has a responsibility, and if he fails, then he could be taken to the tribunal? You see the point I'm making? Because there has to be some limit where you impose duty of care on persons who oftentimes are distant and have no control, have absolutely no control. You see, and I mean, in a sense, that owner of, let's say, a business establishment, let us say a nightclub, a bar, an entertainment spot, where a fair amount of harassment takes place, to say that the owner could be brought up before the tribunal would be a serious challenge for this bill.
Madam Chair?
Thank you, Minister Chuck. I'm going to take Senator Long more than Senator Morrison. I'm sorry, Mr. Bailey. We'll take Mr. Bailey first, and Senator Longmore, Senator Morrison, and then I'll come back on this side. Go ahead, Mr. Bailey.
Thank you, Chair. I was feeling very lonely up here. I think Minister Chuck has hit on, perhaps what is really the core of the concern of Mr. Serraton, which is something that has been presented to this committee already, which is the issue of street harassment, as it's been called. So perhaps while the examples are difficult to discuss, I think the core of his concern really relates to that difficult subject of street harassment, which is something I think the committee has heard some submissions on and will have to make some decisions on as time goes on.
Thank
I also
you.
should point out, just for the sake of Mr. Saratan also, that if you look at sections 5 and 6, clause 5 and 6 of the bill, it imposes a duty on the employee or person in charge of an employer or person in charge of an institution to take action when complaints are made to them. And so it is not simply a jump from harassing action straight to tribunal. Either the person in charge of the institution or the employer should take, and we would hope being responsible persons would take the appropriate action so that it doesn't have to escalate into the scenario that Mr. Saratan has painted, where people's reputations can be damaged unnecessarily. So perhaps he can take a look at what clause 5 and 6 have to say. And there are also, and there are confidentiality provisions also.
Thank you. Senator Longmore.
Thank you, Chairman, Chairwoman. Good afternoon, everyone. JN plus Mr. Saratan. In a past life, I was the executive director for JN plus, actually. So I am very familiar with your work, and I congratulate you for being here. Who is JN plus? Ah, sorry. Okay. Ah, because I saw it bullet listed underneath, so I just wondered whether or not. Okay. Okay. All right. Well, that kind of changed the perspective. But in terms of your concern with respect to the sexual harassment, and one of my concerns is the greatest ill that happens when you're sexually harassed is actually the psychological damage, the mental damage. We have nobody from the technical team that is reflecting on the mental capacity of this. And I find that is actually I've seen that in another joint select, and it's a concern, because we have to recognize that is, you said, Minister Chuck hit the core. For me, the core is the actual damage that is done. And it relates to calls for things like a sexual registry. So the issue could be not necessarily for the agency to act and to be obligated to act, but for the individual to be able to make a complaint. Whether or not we are using technology for everything now, this could be easily done via an e-method, where someone was on bus route, this, that, and when someone makes a repeated complaint, or it is escalated to a number of, there has to be some kind of intervention. The perpetuator has taken this thing public. He interacted with this person in a public way and such. So the response could be public. We have to get serious, and this issues around and punishment of sexual offenses has to get back to the point to what works. These things, when we say that it makes no sense for us to do this, we have to demonstrate a culture and an attitude towards a lack of acceptance of this, because it filters down, and eventually, hopefully, the message will get across. But we have to make it such that get back to where you publicly recognize this person. So you put up photo. You run the risk of your photo being demonstrated on the outside on the inside of the bus or something. But this is after maybe the 10th complaint, etc. or so, but not immediate. And so you are passing it on into the society that this is what we hope to expect, and we are hoping to enforce that. So I think there needs to be some mechanism for some response, but not protected against abuse. Thanks.
Thank you, Senator Longmore. Senator Morrison.
Thank you. When I listened to your presentation, Mr. Saratan, the song came to my mind, sometimes sorry just isn't enough. Yes. So I actually believe that clauses 5, 6, and 39 very adequately respond to the concern that you have. But the gravamen of what you're saying must not be lost on this committee. We cannot have persons accusing individuals falsely of sexual harassment. And I suspect that this is what you want to be made very clearly in our public education exercises. That's the first point. Because you may just falsely accuse someone, and yes, it may go through the process, but what may linger in people's mind every time they hear your name, and it's something that we can't, we're human beings, it happens, they will attach you to an incident of sexual harassment. When I read the first bill that was drafted, I think if I should go back to it, the punishment might have been 3 months, but there was a first draft.
It has never. I think we need to be reminded that we're not dealing with with criminal offenses. So there's no criminal offense attached to sexual harassment. Remember, it's just civil liability, where a complaint is made and you're compensated in damages, and that's the purpose of the tribunal. So there was never any criminal liability.
No. The first document that I got, Minister, remember I called you once to ask you about it. That was the first thing. That's now out. I remember being very passionate about a particular point that you were raising. Yes. I said, hold on a minute. The first draft, yes. Indeed. And I was saying to myself, how can it be that someone is going to falsely accuse the person and the punishment is so light? I was all fired up to take that to this committee. But upon reading clauses 5, 6, and now 39, right, I am content with the provision being made here to deal with it. What I'm finding, what I'm very excited about, though, is the bullet point, the third bullet point that you have here, right? It must be noted that one's perception of an action by another does not in any way dictate or define the actions of that person. And so this act must and should ensure prescribed standards to be met for an act to be classified as harassment. So I'm very excited about that point, because I figure that what you're saying is that your interpretation of what sexual harassment is may be very different from how I see sexual harassment. But I want to go by the definition. Sexual harassment means the making of any unwelcome sexual advance towards a person. And sexual advance is very clearly delineated here, right? So I'm calling your attention to that portion of the bill, right? And ask that you peruse it to see if you still have the concerns that you have. But overall, I respect your presentation, very timely and something that we ought to take into serious consideration.
Thank you, Senator. Yes, go ahead, Mr. Sarah.
Madam Chairperson, if I might just respond to Minister Chuck. Minister Chuck, to say that a lowly bus conductor or driver of a bus doesn't have a duty of care to its passengers. If they didn't have a duty of care, then they could drive and do anything that they want and kill the people in the bus. No, it's a duty of care. A duty of care to the security of the passengers within their control. A duty of care. The trauma that the person would have gone through, isn't that concerned with safety?
You must be careful, though. You must be careful that what you're saying is the fact that is the same set of passengers. For example, take the bus, and one of them is really make too many unwelcome sexual overtones or suggestions. And to say that the driver or the conductor has a duty to stop that person, there might be persons on the bus who welcome it, but there are others who find it unwelcome. What are you saying, that the driver or the conductor must make a decision because one or two persons complain? I mean, as far as I can see, I can't see how the driver or the conductor has a duty to protect the passengers from unwelcome sexual harassment. That's all I'm saying.
You want to respond? Please go ahead.
Minister Chuck, I have 2 daughters. And I've taught my daughters to, while they do get a drive to and from school, I've taught them how to take the bus. Because I think it's very important that they know how to navigate their way in this world. And for my daughter to sit on a bus and a man rubbing his genitals on her.
That, by the way, is a criminal offense.
I understand, but you see, my daughter might not see it as an offense, as a criminal offense. She sees it as a sexual harassment that she can now say to the driver or the conductor, take this man off of me.
No, that should be reported to the police station.
But then... Okay, I'm going to ask Senator Scott Motley, but just before I do so, I'm sitting here and I'm listening to this conversation, and it takes me back to an experience I had as a young girl growing up in West Kingston. I'm coming from school, I'm on a bus at Crossroads. The bus is packed, a man is standing behind me and rubbing up himself on me, and I use my elbow. And just because I pushed him away, he slapped me. That's right. No. But to be honest, the driver and the conductor did nothing, and I'm not sure they could have done anything. Right? So this will happen. The question is, I don't think we can have this legislation treating with something like that, but it is a reality.
It's a reality.
It is real.
Yeah.
Senator Scott Motley.
I want to thank you very much for raising this issue. It is a very important issue because it's very personal to women. Usually, the woman is a victim. But I want to say that this piece of legislation, I think we need to put it in context. And I think the public sensitization program, which we will have to embark on, will put it in context. I have listened to some of the recommendations which have been made previously. And I've also pointed out that I've listened to some of the programs on it, for example, where they were talking about catcalls. And I heard how grieved the persons who were the victims were. But even when we say that and we recognize that there are so many instances where women feel violated and abused, we have to still go back to the fact of what it is that we are doing here now. My concern is that our first step in this matter of sexual harassment has to be to present legislation which is workable and which is enforceable. At this point in time, it's focused on the workplace and institutions. And I think it's very important because we see where we need to go, for example, in protection of your 2 daughters, that we have legislation that starts out as being effective and enforceable. If we try to address every one of the feelings that we have which are hurt, because it's very personal, you know, it's about how you feel, we might never really achieve the objective that we have set out to do. So what I would try to say to you is that you have to be patient with the process. Your intervention is very, very important, but we have to follow a process. And I think one day we might get to the point where you want us to get to, but right now this is the urgency which confronts us is dealing with it in the workplace and in institutions. And I also want to make one last point, because I took into account what you said about prominent persons and how their reputation is damaged when an accusation is made. And I want you to also apply that to somebody on the bus who is accused of doing something like that. It goes viral all over social media, and it's really not intended on his part to have done that. So in a way, we have to look too at how we balance all the interests. And the man on the bus who is going to be accused, who might be accused, also has to be taken into consideration, because the impact on his life can be just as damaging as the impact on a powerful man's life. So in conclusion, I say yes, I am grateful that you have raised these instances. They are real instances. But I don't think that in the context of what we are doing now, we can address all the violations. So I'm really asking you to bear with us as we are embarking on this journey. I thank you so much.
Senator Longmore.
Thank you, Chair.
Thank you, Senator Scott Motley.
Thank you, Senator Motley, because you helped me to also bring across the point of the public education, and more so also enabling persons to recognize their responsibility to act. So I fully sympathize and empathize with the situation, and yes, and understand. But we also have to be practical and not get more caught up in frustrating bureaucracy, et cetera, that could also, and points of abuse in terms of false accusations and stuff. But I go back to the overarching presence of a sexual crime or a sexual offense that is of a psychological nature. And how do we tap into that and make that answerable to? And one of the suggestions in my mind is, in terms of us looking at a possibility of a sexual registry or some sort of areas or points of knowledge of these persons, is that there is an arm that deals with this too, that persons, as I indicated or suggested before, that persons have an avenue to make a complaint and are able to possibly recognize that some action can be taken. And it is not just recognize that, okay, it is an accepted thing, is a part of culture, it is not, we have to find some intervention. We're here dealing with this monumental legislation, and we probably won't get back to this process anytime soon. And we have to recognize that if we don't address it now and send the message, this is one of the messages that we are doing now, is sending a message against sexual offense, that we have to recognize that there is that category of psychological damage that might not be immediately proven, but certainly is damaging now and in the future.
Thank you.
Who's going? You want to go? Oh, who is up? Okay. The point that Mr. Seritan raised is real. That's the first thing I'm sure you have discovered from the members of the committee. There are persons, mainly male, who carry out the same kind of activity you described on public transport, over and over. You would hear from some schoolgirls that they are not going on this particular bus because of this man who traveled every evening going up on the bus. What this not even this legislation, in the public education, that man ought to be reported, because the same action that he's carrying out every day, squeezing up on people, rubbing up himself on the girls and the women in the bus, it's an offense. Am I not correct, legal minds? And ought to be reported.
And it usually escalates.
Yes,
It usually escalates.
And ought to be reported. I don't want you to feel, as our other colleagues have said, that we are looking at this point lightly, because it is real. What is happening out there in the society is real. Every single morning, every night, every day on buses. And I think we will have to, in the public education, remind the public that where instances of this occurrence, it is a criminal behavior, and it should be reported to the police. That's my comment now. Well, come again, it's not to Minister of Injustice, what it is? I'm Minister of Justice. It's a criminal behavior. Right. And I think it ought to be promoted. People must know. Some people, no, my friend. Some people don't even realize, Chair, that they have, that is a criminal act. And the poor students or the woman been facing with this thing for months, day and night, every day, from this particular man. Because in many instances, it's not a lot of persons, you know. There's this individual who does this act all the while, and they don't even know that it's a criminal offense. So I think we have to promote in our education this particular,
Actually a battery.
yeah, that's how it is described in the law. Yeah,
Assault and battery.
assault and battery. So, but really, thank you for raising it. Okay, thank you, Chair.
Thank you, Member Daly. Mrs. Senator Fraser-Binns, you wanted to make a comment? Okay. All right. Thanks.
What would have been
Senator Gale?
What would have been evident? The objects of this piece of legislation, in the first instance, was seeking to deal with what would have been employment related and institutions, and by extension, landlord and tenant relationship. What has come out, and Mr. Siratan, you're not the only one, because we would have listened to other presenters, making the plea that it's a critical issue in the public space, outside of what is contained in the legislation. The issue is that how you treat with it in the public space, and it brings to the attention that it has to be dealt with. Because the mere fact that we are bringing this piece of legislation, it just attracts the attention that there are challenges in the public space that must be dealt with. And you see, it's not ironic that the Justice Minister is part of this panel. So there is work to be done, but I want to commend you for as an individual for bringing it here. But then, Douglas, I know you. You're a BITU union delegate and a strong advocate of the workplace. So it wouldn't be unlike you to be representing this issue, and your colleagues would be very proud of you.
Thank you, Senator. I don't know if Mr. Bailey wants to wrap this. Okay, Mrs. Senator Fraser-Binns.
I just want to say something quickly, and I'm not going to repeat anything that has been said, but I wondered, Minister, in light of the conversation that we've had at prior meetings and the discussion here today, whether the ministry would consider a joint public education on this new bill when it becomes law, and the law that already exists that deals with matters similar to this. Because it seems to me that it's either there is not an awareness that legislation does exist that can deal with some of these issues, or it is that the legislation is not enforced. I'm not quite sure what it is, but it may be useful for us when we start doing our public education about this piece of legislation to remind persons that we don't need to put certain things in it because the laws already exist, and this is where it exists, and this is what needs to be done, and this is how it is treated, and this is what you need to do. So I'm just recommending it to the ministry for when we start that process.
Excellent idea. There are certain laws that do exist that would address some of these things, and then there are considerations of introducing other pieces of legislation to cover some of these matters. Mr. Bailey could just wrap this whole thing by saying what are the other pieces of legislation being considered.
Thank you, Chair, for the invitation, but it's not so much legislation being considered. Section A2 of the Sexual Offences Act, and I will simply quote it, an adult commits an offense where he or she for a sexual purpose does any act specified in subsection 3. And subsection 3 states, the acts referred to in subsection 2 are touching directly or indirectly with any part of his or her body or with an object or with any part of the body of the child, or inviting or counseling or inciting a child to touch directly or indirectly any part of the body or with an object the body of any person, including the body of the adult or the child. So the activities described by Mr. Siratan and the experience you shared, Minister, would directly fall under this. This is a serious criminal offense already.
Thank you so much. I mean, we have aired this matter quite a bit, and I think that Mr. Siratan is quite pleased with the exchanges that have taken place. Pardon? Yes. And so I'll give you the last word, and then we're going to wrap this discussion here.
Just wanted to thank the committee for the opportunity to hear my views on the matter, and that's it.
You have represented your colleagues very well. So we will now take the next presentation. It's Ms. Tajna Lee Shields from Jamaica Network of Seropositives. All right, please go ahead with your presentation.
Good afternoon.
Sure, you can leave. Yes. Thank you so much for coming. Great. And maybe Ms. Shields, you may want to come and sit in the front row there to make your presentation. Please wait. Thank you. One presenter from your organization, or both of you? Right. So you maybe you could sit immediately behind her. Yeah. Please go ahead. Thank you.
Okay, I'll go ahead. So good afternoon, committee chair. Good afternoon, members. My name is Tajna Lee Shields, and I'm the Policy and Advocacy Officer at the Jamaica Network of Seropositives. Right behind me is Mr. Jamoki Patrick, who is the Executive Director at the Jamaica Network of Seropositives. So Jane Plus, which is what I'll use to address the organization from now on, is a non-profit advocacy organization that works to provide peer-to-peer support and support groups for persons living with HIV and their affected families in Jamaica. So we collaborate locally, regionally, and globally with other networks, other stakeholders, and partners in the HIV response. At Jane Plus, our main mandate is to provide care and support for people living with HIV. Sexual harassment is globally recognized as a form of violence against women, and more broadly, a form of gender-based violence. The World Health Organization reports that gender-based violence is not only a human rights violation, but it is also a barrier to HIV prevention, treatment, and care. Sexual harassment directly and adversely impacts women living with HIV in Jamaica. Gender inequality and gender-based violence are two direct pathways that have even greater impact on HIV transmission than the direct pathways. And in Jamaica, where patriarchy and unequal gender norms are a big part of our culture, men are more likely to perpetuate sexual violence, to pay for sex, and are less likely to use condoms. Now, sexual harassment is a critical issue which represents the tip of the iceberg in Jamaica's rape culture. Now, rape culture refers to the situation that exists when a society or an environment has social attitudes that have the effect of normalizing or trivializing sexual assault in the country. In Jamaica, this looks like the saying, "adjust a man stay," when men make lewd jokes about women, or saying that young girls love big man in cases of sexual grooming and sex with a person under the age of 16. So the recommendations that are being put forward by JN Plus are split into two categories. So there are recommendations for the act itself and also recommendations for establishing an enabling environment for the act. So our first recommendation is street harassment should be included in the act. Now, it is paramount that the Sexual Harassment Act pays attention to the startling reality of street harassment outside of the workplace, and particularly on the street where it is faced most. Street harassment refers to unwanted comments, gestures, actions forced on a stranger in a public place without their consent, and it is directed at them because of their actual or perceived sex, gender, gender expression, sexual orientation, or health status. It includes unwanted whistling, leering, sexist, homophobic, or transphobic slurs, persistent requests for someone's name, which we're accustomed to in Jamaica, their number or destination, which we're also very accustomed to. After they have said no, it includes sexual names, comments, and demands, following, flashing, public masturbation, and groping. Unfortunately, when women living with HIV in Jamaica face street harassment, their HIV status becomes a part of the exchange. So according to data from reports of discrimination made to JN+, women with HIV experience 6 in 10 reported human rights violations. Disclosure of one's status without consent represented 4 in 9, and that's 45% reported violations by people living with HIV. Similarly, this is represented more often by harassment and verbal abuse in the community context, and it accounts for 48% of the reports that we get. In one particular case, the client has been suffering from severe harassment and verbal abuse in her community since the disclosure of her status by a nurse. Due to the abuse, she was forced to stop selling in the market, which has resulted in emotional discomfort and financial instability for her. Now, we understand that this will be difficult to outlaw because of how deeply ingrained in our society street harassment is, but while it won't be easy, it is absolutely necessary. We suggest that the House consults legislation such as South Africa's Protection from Harassment Act, that's 2010, and the United Kingdom's Offense of Causing Intentional Harassment, Alarm, or Distress. The second recommendation is that the definition of sexual advance should be expanded. So while the current definition is a good angle from which to approach sexual harassment and sexual advances, its expansion would allow for a clearer understanding of what is considered sexual harassment. We recommend that the following are added to the definition. So A, asking a person intrusive questions of a sexual nature that pertain to that person's private life. B, transmitting sexually offensive writing or material of any kind, including by social media, C, making sexually offensive telephone calls to a person, and D, or other sexually offensive or suggestive conduct of an offensive nature in circumstances where a reasonable person would consider the conduct to be offensive. And these recommendations are supported by the Employment Sexual Harassment Prevention Act of Barbados, and that's 2017. Third recommendation, the law must outline and explain the different spaces and ways in which sexual harassment takes place. So the current act goes in depth with how sexual harassment will be addressed in the workplace, but does not say much about the other institutions. So the act must be framed in a way that makes it predominantly clear that all institutions are protected under the act. Discretion should not be left to the minister to decide what institutions are protected from harassment. Fourth recommendation, sexual harassment among peers should be specifically addressed. So the act refers to co-workers and the duty that co-workers have to not sexually harass other workers, but we recommend that this be changed to include peers and colleagues, as sexual harassment among colleagues occurs in professional institutions outside of the workplace. It should also be noted that harassment is not only top-down, but that the creation of a hostile environment which makes people uncomfortable is also a form of harassment. Our fifth recommendation is that the authorized officers referred to in Part 4 and the full tribunal referred to in Part 5 must be thoroughly sensitized on sexual harassment. It's very important that these officers and the tribunal who oversee the regulation of the act are properly sensitized on sexual harassment. So they should receive sexual harassment training that is based in human rights principles. It is paramount that these people have a general, similar understanding of sexual harassment, including the cultural nuances, the examples of what constitutes sexual harassment, and the ways to approach the issues that they will come across. And this is different than public sensitization. It would be much more in-depth. Our sixth recommendation is that there should be no statute of limitations for reporting cases of sexual harassment. So Part 4 of the Act speaks to complaints and other claims of sexual harassment, and it's vague. It does not clearly specify if the 12-month period that is given to submit a report falls on the complainant or on the employer. They should be clearly specified and should assert that no statute of limitations exists for reporting cases of sexual harassment. Now, this is due to the traumatic nature of various forms of harassment, and that complainants are not always ready to make a report right away. So similarly to the offense of rape, a statute of limitations could cause serious restrictions for persons working through that kind of trauma. Our seventh recommendation is the prohibition of victimization of employees. So employers should be prohibited from carrying out any action which adversely affects opportunities and terms of services for any person who rejects that employer's act of sexual harassment and lodged a complaint under the act, giving testimony with respect to an investigation being conducted or hearing held under the act. These recommendations are also supported by the Employment Sexual Harassment Prevention Act 2017, again, of Barbados. Our eighth recommendation. So no limit should be needed for Section 4, Part 4 of the Act. Many Jamaicans aren't operating in the complex corporate structure which requires 20 or more employees. The Act gives protection for domestic workers in one hand, but then takes it away with the other hand. So no quota should be specified for this. There should be a standardized policy that captures all entities. And the law should clearly indicate that sexual harassment is prohibited in all spaces and allow for redress. Our ninth recommendation, which is the final one in the recommendations for the Act itself, is refers to the section of the Act which speaks to immediate and appropriate actions, and that they should not be left to the discretion of the employer. So the purpose of the bill is to set a non-negotiable standard. Section 5 does away with that by not framing what is immediate and what is appropriate. If Parliament leaves these open-ended, the court will view this as Parliament's intention to take each employer and each case of harassment as it finds it without a proper threshold of unacceptable conduct. In Section 6, Part 1, and it says, where the person in charge of the institution becomes aware of the harassment, it's too narrow. So actual, imputed, and presumed awareness is needed. A blanket aware does not gives people too much power to hide in ignorance. So instead, the law should say that where the reasonable man would be aware of. Reporting mechanisms must also be established so that employers can be held accountable for not taking action where a report was filed. Going on to enabling environment, and these are things that we think should be in place to ensure that the environment that people are working in gives space for reporting sexual harassment. And we've spoken about so far today about the sensitization. Going to go into that a little bit more. The public sexual harassment sensitization should be undertaken by the Ministry of Labor, the Ministry of Education and Culture. The Labor and Education Ministries should collaborate on a public sexual harassment campaign to sensitize the general public on sexual harassment. And this is to ensure that the public is aware of what constitutes sexual harassment and the remedies that are available. Efforts should be taken to sensitize all Jamaicans through mass media. And the second recommendation under enabling environments is that appropriate counseling services must be made available to persons who report cases of sexual harassment. And to zoom in a little bit on that, appropriate counseling services should be grounded in human rights. It's important that action be taken to alleviate the emotional impact that sexual harassment has on complainants. Confidential sexual harassment counseling services can offer support to persons who are victims of sexual harassment. This counseling can be very effective in mitigating the impacts of sexual harassment, and the counseling must include information on how redress options that are available and tools to cope. So at no point should the counseling services be telling someone who makes a report that this is how they can find peace with it without letting them be aware of the redress options that are available. And with that, we thank you.
Thank you. Thank you. Good presentation. I think Ms. Grant, Georgette Grant, wanted to make a comment, and then Senator Gale. Senator Longmore.
Yes, Madam Chair, I have two questions for JN Plus. The first has to do, and the other is that section 4, subsection 4 that you made reference to, read the 20 persons or more in the workplace. That was in a previous version. It has been removed in this one that we are currently looking at today.
Okay, thank you for that.
Yes, Senator.
Very good presentation. I just want to point out or respond to two particular areas. For the sexual harassment among peers, because we take for granted that you work with persons and it's not confined to the workplace. But if you go on field trips, if you work outside, if you go at seminars or a workshop, the act may take place and the perpetrators are there. And a suggestion was made in an earlier presentation to expand the definition of workplace to include outside of work. But I'm particularly pleased about your reference in terms of number 9, the question of the victimization. And your reference to the legislation in Barbados, that whilst 38 might be seeking to treat with it, what it says in the Barbados legislation in a different way: no employer shall carry out any action which adversely affects the opportunities and terms and conditions of employment of an employee who has A, rejected the employer's act of sexual harassment, B, lodged a complaint under this act, C, given testimony with respect to an investigation conducted or hearing held under this act in connection with a complaint of sexual harassment, or D, participated in any investigation, procedure of hearing under the act. The approach taken by what is contained in this legislation as opposed to what 38 is seeking to deal with appears in my mind more explicit, stronger in terms of emphasis, because when you warn the employer that no employer shall, it gives greater emphasis. Because we would have seen in workplaces where employees would have raised the concern, investigation took place, and whatever the result may have been, that employee would have faced adverse effect in terms of victimization after that. You overlook for promotion. Your bonus looked different. Your appraisal was not the one that you had gotten before, where you would have gotten a C being exceeding expectation. You're now getting average. And we have seen it in organization. And I believe the way that 38 should be written must give a strong warning against victimization. So I'm very pleased when I saw your representation of that.
Thank you, Senator Gale. Senator.
Just in response to the first thing that you made note of, the peers and colleagues, that is not supposed to be restricted just to workplaces. So we were thinking about institutions like universities, for example, where sexual harassment, we can easily see top down, where, for example, a lecturer might be harassing a student, but it should also be applicable to the peers and the colleagues around that student.
Senator Longmore, Senator Morrison, and then Member Daly, in that order.
Thank you, Chairman. Again, congrats, JN Plus, and proud for the connection. It was Senator Gale before, now my turn. I congratulate you also on your reference to the legislation in Barbados, and I agree with you, Senator Gale. It was something that I was going to speak on, but also your call for the appropriate counseling services. And what I really particularly appreciate is for it to be grounded in human rights. I think we significantly need to be recognizing that. I'll just put that out there, recognizing it across almost all pieces of legislation in terms of the right to that aspect of humanity. And also within the counseling services, the obligation to inform of alternatives or options for resolution. I think that is significantly one of the issues and a separate aspect of the PR. We keep talking about the public education that has to happen amongst the persons who are treating and who are seeing to the resolution and the mechanisms that people may be reaching out to. So the person who presents with a panic disorder in the emergency room, who goes to see a doctor there because she is paranoid about going into her workspace or his workspace, that person must know of the avenues, and there needs to be an education around the technicians and the therapists and the workers who deal with the issues so that they can then guide the direction, and stemming that to be a part of the obligation regarding the counseling services, I think, is also quite significant. Thank you.
Thank you. Senator Morrison? And then Member Daly, then Member Chuck.
Thank you very much, Minister. Excellent presentation, right? And I like that the point 9 that you mentioned and the response for made the provision in clause 38. Yes. Senator Gale, I'm liking the approach that you're taking, right? Your insistence on the proper wording, which is going to show that we're going to put much teeth into this. Because, Minister, it has often come to the attention, sometimes anecdotally, that women especially who serve in the security field, in the security industry, right, they face much victimization. So today they are working in Spanish Town, and suddenly they are transferred to Montego Bay. They are frustrated out of the job. Right, so this has come at an appropriate time where we have to take a stand for individuals within the workplace who, because they dare to complain, people frustrate them out of the job. It seems to be a very prevalent thing in our country. You're working in St. Catherine, suddenly you're in Montego Bay, and we encourage employers to put the different contingencies in place where you fully investigate why is it that this person who was working in Clarendon for years doing a good job, what's the reason, what's the supporting argument why you're suddenly transferring this individual to Trelawney? Excellent point that you have raised there. I want to look at, I'm looking at point 2 that you have raised, the definition of sexual advances, that it should be expanded. You are saying here that the current definition is good, but you are asking that we also consider a person asking intrusive questions, questions that are of a sexual nature, that be added. Wouldn't you find favor with the definition given? If you have the bill with you, if you look at the definition of sexual advance, point C, the making of sexual suggestions, remarks, or innuendos. Let's continue to D, the showing of pornography or the display of images or objects of a sexual nature. Don't you think that, are you of the view that C or D could sufficiently cover the concern that you have raised there? And my final point, I think it's at 11, the purpose of the bill is to set a non-negotiable standard, and you are looking at what should be considered to be immediate action. Let me see. Hold on a minute. Please open it. Okay. Yes. Section 5, which speaks to immediate and appropriate action, should not leave such actions to be judged by the employer. I would like to hear the views of the committee as it pertains to this. What is considered to be immediate and appropriate action? Is it that you would like to see this limited or confined to time, a particular time marker on it? Because my layman understanding is that immediate means immediate and appropriate action would have been defined. So I'd like to know your thinking and what the committee thinks.
So in that same recommendation, if you look down at section 6(1), it leaves it to where the person in charge of the institution becomes aware of the harassment. And we believe that that is too narrow. So aware of the harassment could be, take for instance, there's a situation where the harassment takes place every day in front of my employer, right? It takes place in front of my employer, and until I come forward and say to my employer, hi, this is what's going on, I have a problem with it, that is when action is taken. Now, it's not immediate action if that's what you're waiting on to take action. So when you become aware should not be when someone comes and makes a report to you. It should be, if you see this happening, going on in your workplace, then you should take some action on it.
Hold on.
And that
but hold on a minute. Isn't that heading into choppy waters? Very choppy waters.
So
hold on a minute. Keep your powder dry. I see you in the workplace every day. Keep your powder dry. I see you in the workplace every day. You appear to have a very good relationship with Billy. Right? There are days when you are there, him hold you by the hand, whatever. Are you going to say that I am aware? You could always deny it at a later date. You could say no. I believe that the point of awareness ought to be, you know what? And maybe it's not unwelcome too. So we have to ensure that we are careful with that. And I want to have my colleagues here who are experts at law to give us their perspective of what is considered when you can become aware of a matter. What is awareness one? And I am not sure I'm happy with how you are conflating the two things. Stay with me, Senator Scott Motley. I'm not sure I'm happy. I am not, yes, you, behave yourself, remember. I'm not sure that I am liking how you're conflating two things. One, about becoming aware, and two, immediate and appropriate action.
Yes. Ms. Shields, you're going to comment?
Yes.
Okay.
So thanks for that. So in the act that is here, it speaks to the duty that employers have to ensure that the environment is not one that facilitates sexual harassment. So I'm assuming that if that's a situation that an employer would be aware of, that some action would be taken to ensure that this is something that whoever is comfortable with. Because one of the crux of sexual harassment is that it's unwanted, right? So if an employer sees something going on, then it is his or her responsibility to ensure that this is something that is wanted, this is something that everyone is comfortable with.
You're leaving up to me to judge that? You're leaving that up to me to judge that?
No.
Yeah.
I'm good.
Yes. Yeah. We have to remember about individual rights.
As I said, no one is being left to judge that. Clarity should be sought. So the employer should seek clarity in a situation like that and ensure that it's not an environment that is facilitating sexual harassment.
Member Daly? Member Daly? Then.
Yes. First of all, Tajnali Shields, I have to add to what my other colleagues have said in commending you and your Mr. Patron. Patrick, Mr. Patrick, Junior Patrick, or what?
Jamoki Patrick.
Jumoki Patrick. For a very thorough, obviously you guys have really spent some time go through the bill. In fact, at first, I said to my good friend, Mr. Minister Chuck, that there goes a good comrade. Because you had on your full red. Then he said to me, look at her nails, they're green. So I replied to her, I replied to him and said, she's truly non-aligned. No, but I really have to commend you. When you see young people spend the time to do this kind of work, I have to commend you. Even though we don't agree with everything you have put forward, but to take the time to go through this bill, clause by clause, and make your comments is really promising for our country. We appreciate it. Like other people who have spoken before, we understand this issue of sexual harassment, especially where the bill cites workplace and institutions. And we know that women are the most sexually harassed in Jamaica. I was going to say in the world, but in Jamaica. Senator Gale mentioned the thing about promotion. There are women who have had to forego or bypass promotion because they do not agree, or leave the jobs, true, because they don't agree with the advances, sexual advances that are being made upon them by their bosses. And of course, there are male who face the same thing too. But, in section 6.1, when you said it should be expanded, I have to disagree with you that it is almost impossible when you're writing a bill, which is preparing a legislation, to go beyond becoming aware. Becoming aware might be reports made. Becoming aware might be another colleague make the report, because it might not have to be the harassee. It's such a word. A creative word. It might not be the victim. Might be so ashamed, so nervous, so stressed that she doesn't want to go and report it, but another colleague reports it. That's how the boss, that's how the head of the institution become aware of the sexual harassment. It might be the husband of the woman might write a letter to the boss to say there's somebody in there who's doing this to my wife. She might complain. She might just be so afraid to complain to her husband, or partner. And I'm saying it is difficult to have anything else other than where the person in charge of the institution/workplace becomes aware of the harassment, then actions are taken. I don't know what else could you expand it to include. And this is where I would ask you to tell us what else would you put other than being aware.
So the recommendation that we made was that it should say where the reasonable man would be aware. Where the reasonable man would be aware.
I'll ask Minister Chuck, who wanted to make a comment, and then.
Firstly, it's a particular unit of the Ministry of Justice, which we don't advertise as much because it is overburdened with work, and that is the Victim Support and Counseling Service. You know, it does a lot of work, but oftentimes it's really cases that have been referred to it by the courts, by the CISOCA, and so on. But there's no doubt that there are other areas where, like sexual harassment, persons who have suffered badly from sexual abuse or sexual harassment, they do get counseling service. And Reverend Bailey, must be a cousin of Maurice, not a cousin, Osborne Bailey, Reverend Bailey, they report thousands of cases regularly where they give counseling to victims, you know. So to the extent that you ask that there should be more counseling, you know, for this, there is such a service. How much we can expand it, you know, is another matter. Now, on the second point, you see, human relationship is very complex. And, you know, to ask that the workplace be responsible for the sort of what you are really calling for paternalistic endeavors or social engineering at the workplace. It's a call that is extremely difficult, you know, to ask the workplace to be responsible for that sort of human relationship and promoting it. They can do it informally, but to impose a burden on them would be almost impossible. In an earlier life, you know, Ms. Shields, in an earlier life when I used to teach at the university, about 30, 40 years ago, much earlier life. A much earlier life, you see. One of the things that I always pointed out is when you look at how men and women behave, they're driven by different forces. So you see, men basically, unless they're restrained by education and good personal upbringing, they tend to be brutish in their behavior because they're driven primarily by sex. You know, the sexual drive is their strongest drive. Well, it's different with, and some very uneducated men believe that women are also driven by that, when that is far from a woman's mind in any sort of encounter. You know, what is foremost in a woman's mind is security. How am I well secured in my job, in my general transaction as they go about their business? So there is this dichotomy, you see, because they're really at opposite end. The woman who wants to be secure and the man who wants to be adventurous, you know, and to take advantage of a woman. So it is a difficult relationship. Right. You see, so to ask, I mean, who do you ask to be the mediator in between those two positions? To say it is the employer. I don't know if that's fair. You see, it's just not possible to ask the employer to be that person that makes that problem resolved. So the point you're making is one that needs education. There's no doubt about that. The one that, you know, yes, we should promote proper behavior, especially amongst our young men who, you know, feel that, you know, any suggestion they make to a woman should be taken as appropriate. And many of them don't appreciate that their behavior is brutish, you know, because it comes naturally to them. But how do we restrain, you know, our menfolk and to appreciate that women are much more sensitive. They're more open, I mean, to a different form of behavior than just this aggressive jungle behavior that most men feel is appropriate. You see, so in all sincerity, I don't know how you're going to get men to just appreciate the finer things in dealing with women. It is a troublesome challenge.
Thank you, Minister Chog. I'll take Senator Longmore and then Senator Gale.
Thank you. I appreciate the effort, Minister Chog. I think it goes back a bit to, I understand what Ms. Shields is trying to accomplish, but again, I have to agree with my companions in terms of probably an overemphasis on the parental role that is being required to ask and of the employer. And also, we don't want to you don't want to make the workplace environment where you're walking on eggshells also. There's also that. But I go back to the possibility, and I know we're not there yet, but of a sexual registry. And a mechanism and enabling the individual. Every citizen should know that, especially if there is a circumstance of a repeated offense and a repeated offender in a particular place, they are able to make some sort of report, whether just kind of file this thing online or something, whether it be connected with the Justice Ministry, or for me, because of the psychological, the Health Ministry, etc., in terms of mental health and offenses thereof. But the fact is that I think you're seeking that every person should know that they are safe and they have an avenue for help if needed. And again, a sexual registry that sees to this also falls into some ambit of that operation.
Thank you. Senator Gale, and then after that we'll take Mrs. Robinson from the Bureau of Gender Affairs and Ms. Grant from the Ministry.
Chair, there is not a day in my working life that I don't beat up on an employer. But when I look at Clause 5 and what Ms. Shields is seeking to do is to apply an additional burden on the employer. But 5, when you look at it, already places that burden, because it says an employer shall take immediate and appropriate. And we have to define what is appropriate, because there might be a feeling from that victim that the remedy that was advanced may not have been appropriate enough. And then, for the employer to becomes aware. Remember, Dali spoke about the different mediums of becoming aware, where the victim might bring it to your attention, as opposed to someone else in the workplace, or just word of mouth, and makes an attempt to treat with it. And I've seen a particular situation where an individual looking on brought it to the attention of the employer, and when the employer sought to investigate it with the victim remained silent and suppressed. Now, when you treat with 6, the person in charge of the institution shall take the appropriate action to deal with the sexual advancement of student or the individual. You form the assumption, or you may make the opinion that, well, as an employer, I took the necessary step. Never resolved the matter, because the individual in that particular case still continue, for whatever the reason, remain silent. And what this is saying to us is that there has to be, coming out of this, the level of education to encourage persons to speak up and know that there is confidence in the legislation for the protection. And again, this is another piece of legislation, Chair, that he's going to have to work in tandem with other policies. Take, for instance, the whistleblowing, where there's a safeguard mechanism that allows for a different type of protection that would complement and support this piece of legislation. So there's a lot of work that we're going to have to do if we're trying to make sure that every clause that we are presented as part of this legislation is able to work. And you won't cover everything. And I see where member Dali is trying to go through an old set of notes.
If I may,
thank you, Senator Gale. While Member Dali is going through his notes, I will ask Mrs. Robinson. I'll ask the presenters, one of the...
Yes, so while I do understand the issue of becoming aware, a point was made earlier about unreasonable burden on the employer in that regard. But for us, we believe it's the duty of the duty bearer, the duty to prevent. So whether it's through policies, protocol, guidelines within the institution or an organization, there should be that environment that enables, whether it's reporting or as a responsibility as an employer, to prevent a hostile environment for sexual harassment. So whether it's a subjective or objective approach, in the form of a test or whatever, or an assessment, that should be done, because the number one thing right here that we're discussing is to prevent sexual harassment. So while I understand the point of being aware as well as when it comes to you, that's when it is reported, or that's when action can be taken. There's also the back end to that responsibility of enabling environment, which we spoke about in our presentation, as well as it doesn't have to be the executive director. There's an HR department that you can ensure that the policies, guidelines, and protocols are within that department to provide that environment.
A preventative approach.
Thank you. All right. Mrs. Robinson, then Ms. Grant, and Senator Fraser Binns, and Senator Scott Motley.
Thank you,
Senator
Chair.
Morrison, and then Senator Fraser Binns.
Thank you, Chair. I like the fact that Jamoke mentioned the HR department, because I wanted to talk a little bit about that last point that she spoke about, the rep from JN+, public sexual harassment sensitization should be undertaken by the Ministry of Labor as well as the Ministry of Education and Culture. So thank you for raising that. We saw that very early when we were doing the discussions, and so we had to have very lengthy discussions with the Ministry of Labor and Social Security because sexual harassment is a workplace issue, and so it resides very well between the two ministries as well as the Ministry of Education, Youth and Information. So the three. So you are right in raising that. And what we also did is that we extended our sensitization, which we had been doing all along, because this matter of sexual harassment is not new. We have had it ongoing from as early as 2008, 2006, and we are very happy now where we are. We're extremely ecstatic that we are at a point where we have a bill that has been debated. And what we did recently in February is that we inked an MOU with under the Ministry of Education, Youth and Information, the Open Campus, UA Open Campus. And I'm pleased to announce that this morning we completed the first in 2 days of trainings for different groups of workers. So this first sensitization was for senior and middle managers in public and private sector. And the responses were overwhelming. We did it via Zoom because of the new protocols. Okay. On the bill itself, and because we know that this is important, and this is going to be continued, we're doing it with groups, different groups, to provide a sensitization. And while we do that, we will explain the importance of personal and professional responsibility, taking parts of the bill, dissecting it, and sharing it with persons. So thank you very much for raising that issue. We are actually doing that, and we also intend to extend that because we have gender focal points in key departments, departments and agencies within ministries. We intend to work through that gender focal point network as well as our gender advisory council, which our minister chairs, to make sure that all of the groups get the information in advance of the completion of this discussion. Thank you.
Thank you, Mrs. Robinson. Ms. Grant?
Madam Chair, two things. First of the two is I just wanted to lend my voice to the discussion about the reasonable man. The reasonable man is an objective test, and sexual harassment is subjective. It is for the individual to determine how do I feel about what has happened to me. So if we insert that, it's going to change what sexual harassment is completely. And the second thing is the time limit. I know that the presentation spoke to no time limit, but then it's a civil, we're dealing with a civil situation. It's not like a criminal matter where no time runs against the crown and you can bring the matter whenever you so choose, but we're dealing with a civil matter. And so there has to be a time limit. If it is that the 1 year is problematic, then I don't know if we could go to the extreme of 6 years. Employers might have a problem with that, but there has to be a time limit because we're dealing with we're dealing with something of a civil nature.
Thank you. Senator Morrison, then Senator Fraser-Binns, and then Senator Scott.
Can I jump the line because what I wanted to say, Ms. Grant has raised, and I wanted to join in commending the presenters for their excellent and thoroughly well-researched presentation. But I had a challenge with the fact that there should be no time limit. Ms. Grant has expressed a portion of what was driving me. That is to say, it's not criminal, so it's not like rape, which is open-ended. It's a civil liability. But I also wanted to say that from observing these matters, because sexual harassment is so deeply personal, it is the person who is impacted is the person who has the recall of the incident. Because of the definition of sexual advance and the broad nature of it, if you take too long to make that complaint, the person might not be in a position to defend themselves simply because they are doing they're being thoughtless. As Minister Chuck said, they are responding in a particular way. They don't intend to inflict harm, really. But the way that I receive it, it's deeply harmful and personal to me. So I feel that the time frame is important because you also want to be fair and just, and you need the person who is being accused to be able to respond. I don't know if you watched the Kavanaugh hearings. Kavanaugh, when he was, I realized that to him it was nothing. It meant nothing to him, you know. This is what he did all the time, drunk and force himself on persons. No, that's what I felt. That's what I concluded from the way the evidence unfolded. But for the recipient, it was something that damaged her irreversibly for all her life, to the point where when she got married so many years after, she told her husband because of how it impacted her. And, you know, I appreciate what you're trying to do, but I think that we still have to have a little balance so that it could be our son who is being accused, and we would want him to be in a position where, or your brother, certainly not your son, but your brother who is accused, and you still want to put him in a position where he can actually respond. Thank you, Chair.
Thank you. Senator Morrison and then Senator Fraser-Binns.
Thanks, Chair. You mentioned, sir, I don't get your name. Right. Patrick. Mr. Patrick. You raised a point that should not be undermined, and it's that employers, they have a duty to ensure that the appropriate policies as it pertains sexual harassment are in place. That's a supreme point, and also that they have the duty of care to ensure that the environment is one that isn't hostile, right? And you're saying that that should not come at the back end. Am I representing you well? Yes. And because that point is so robust, we can't therefore afford to undermine it by having awareness being presented in a flimsy way. Tom may be passing me every morning and he compliments me on my hair. Give me another name, Brett, not Tom, because I don't want the president to have a problem with me tomorrow morning. Right? Right? So he passes me and every morning he says, I like your hair. And the employer may just happen to pass one morning to hear when I say, every morning this man passed me and I complain about my hair. Me tired of him and him foolishness, you know. And you are probably seeing that as being aware of harassment. Now, 10 months later, I am married to the same man who was annoying me. Right? You know, people get married in the workplace, they meet in the workplace and they get married. So therefore we have to be very careful, because at the point when we may say, you as the employer and you're aware, you claim that you're aware of it, I may now say, but I don't know what you're talking about. Because the same guy and I, we are happily seeing each other after work. So we have to be very careful. I'm taking you also on that, on the heels of that, I'm taking you back to clause 5, where the employer shall take immediate and appropriate action. Right? And I just want to play law here because I'm learning so much from my two besties here. If we're saying that the employer shall take immediate and appropriate action, it goes further down where the employer becomes aware. It suggests to me that awareness here ought to be something that is tangible, something that is solid, something that is binding, and not just something that I thought that I glimpsed. Yes.
Thank you. Senator Fraser-Binns.
Yeah. So just two quick things, and I want to, not to belabor the point, but the issue of time frame is something that is important. And remember now that this deals with a very specific situation, but it does not take away your right at criminal law, yeah? So if you choose not to bring an action or bring the issue to the attention of the tribunal or to your employer within the 12-month period, then 2 years later decide you want to deal with it, you can, because there's no time against the crown, eh? That's one. Secondly, the issue of the role of the employer, it's very important, and we have to treat it in a very balanced way. Minister, I crave indulgence because I had, in my other life, I had to actually represent a man, a male, in a sexual harassment matter in the workplace. And interestingly, it really, it started up because the female and the gentleman had a very good relationship. You know, one party go away, they come back, they carry sweets, and it was really a good relationship. And then something happened, a misunderstanding happened, and things just went sour. And messages which were exchanged every day, "Hi babe, how you doing? You all right?" were then interpreted as sexual harassment. Yes, and for that year and a half that my client had to go through the process at his workplace, you could see he changed. He stopped talking to the females. He stopped running jokes. He would go away and he would come back with nothing. He said, "I did not even buy a chocolate at the airport." And I saw a person who was friendly and outgoing just morphed into a recluse. And I say that because the way in which he was treated, even before a full investigation was done, was he was found guilty even before investigation. At the end, I mean, the charges were dropped. But the point is that it changed his life. And so the issue raised by Senator Scott Muttley cannot be discounted. We want to ensure we protect our women, but we have to ensure that it is done in a balanced way, because sometimes perception is not reality. And though you can't take away how a female feels, some consideration has to be given to the intent of the person doing the action. Because sometimes it's really just a friendly thing. Sometimes it's a misunderstanding. Sometimes you just want to get back at somebody for something that went wrong. So we have to be careful with that. Paragraph 9. Just to change the focus a little bit. Paragraph 9, you spoke about the prohibition of victimization. I clearly support it. But I wondered whether the provision at clause 7, subsection 6, did not adequately deal with the concern you had. And do you have a copy of the bill? Clause 7, subsection 6, which speaks about the fact that you should not be impacted for the worse. Essentially, that's what it is, once a complaint has been made. And I wondered whether that was not, that your concern was not dealt with there. Also, paragraph 10, you mentioned that there's a loophole, and I read it a few times because I was trying to understand the loophole. Section 4.4. And section 4.4 really, it says that an employer or a person in charge of an institution who discloses any information relating to a complaint or the circumstances of a complaint in contravention of 3G shall be liable, and such disclosure should be of the complainant can go to the tribunal. And I could not understand the loophole you're seeing, because if you remember now, 3F, what it does, it says you must have a policy. And within the policy, there are certain things that must be provided. And at 3F, there should be a statement to the effect that the statement of confidentiality, essentially that's what it says. 3F deals with that statement that anything you say will be held in confidence. But that statement is subjected, yes, there's a caveat attached to that statement, and it says that it can be disclosed where it is necessary for the purpose of investigating the complaint. I don't believe that the issue of confidentiality would be impacted if you disclose the information specific for the purpose set out in 3F. And if my understanding is correct, I'm going to ask you to just explain to me what is the concern you have regarding the loophole which you would have seen in 4.4.
Thank you, Senator. Now, Ms. Shields, you'll respond? Or Mr. Patrick? Okay, go ahead, Ms. Shields.
Okay, so we're unfortunately looking at two different documents. So the loophole that was initially referred to was that the the law had, well, the bill had said that 20, it had referred to 20 employee, yeah. So that's the issue here.
Minister, may I just ask?
Go ahead, Senator Morrison.
The member here, you were looking back at Part 9, the prohibition of the victimization, right? Just for the benefit of Ms. Shields, could you just read that section for us? You called us to, no, could you just, for clarity, Part 3, 7, 6. Yes, if you could just read that to us, because it finds favor in terms of bringing clarity. Yeah.
Ms. Edwards? That's why your union man is. An employer shall not take any action which adversely affects the opportunities, terms, and working conditions of a worker who has instituted proceedings by way of a complaint or claim under this Act, or who has given testimony or otherwise participated in any investigation, procedure, or hearing initiated under this Act. And so the point I'm making, and I think Senator Morrison supports, is that the concern regarding victimization of the complainant or the employee is dealt with at 7.6 of the amended Act.
Yes, Ms. Shields?
Yes, so as I said, we were looking at two different things. For one, but also as, I'm not sure of the name, as was said earlier by Morrison, the act that we specified, the Employment Sexual Harassment Prevention Act of Barbados 2017, it goes more in depth. That's the concern. It's a part of the. No, I don't have it with me. I don't have that with me.
Senator Gale, you want to? Yes.
Chair, it's wider. And it says, no employer shall carry out any action which adversely affects the opportunities and terms and conditions of service of an employee who has, and it now specifies, A, rejected the employer's acts of sexual harassment, B, lodged a complaint under this act, C, gives testimony with respect to any investigation conducted or hearing held under this act in connection with a complaint of sexual harassment, or D, participated in an investigation, procedure, or hearing under this act. And it went further that no person shall subject or threaten to subject another person to any detriment on the grounds that the other person, A, has made or proposed to make a complaint under this act, B, has furnished or proposes to furnish any information or any documents to a person exercising or performing any power or function under this act, or C, has attended or proposes to attend an inquiry under this act or to appear there as witness. What it does, is that it's not only, for argument's sake, the HR manager, but you may have persons who are in collusion who you said to the supervisor, go stop her from talk, you deal with that as an accomplice. So what this it has done is to widen the scope of protection in a more explicit way than what is being narrowed in 7.6.
Chair, if I may, in relation to Senator Gale's point, perhaps clause 38 might be of some use.
I understand the use, but it's just the terminology. In a case like this, I would have preferred to see stronger wording that is more explicit that leaves no question or interpretation in any perpetrator's mind.
So perhaps we should adopt.
Mr. Bailey, you're uncomfortable with that?
No, Chair. I understand Senator Gale's point about stating the duty in a strong and more positive way rather than the way it is set out in Section 7.6 at this point. But the second part of what he was quoting from Barbados actually is basically word for word Section 38.1.
Yes.
A person commits an offense if that person subjects or threatens to subject another person. Notice it doesn't limit it to an employer. And it's the same example that you were giving where somebody's in collusion, for example, to any adverse action on the ground that that other person has made or proposed to make a complaint and so on. It's identical practically to the Barbados provision.
Ms. Seeley, Browning.
I think it's a little, the Barbados provision is a little wider in that in these provisions kick in after a complaint has been lodged. In that case, if you have just refused this sexual advance and you're discriminated against it, you can bring an action. And I think that is something that we can look at and examine. Anyway.
Yes, I'd like to suggest you look at it. Right? Yeah. Thank you so much. Yes. Ms. Shields, Mr. Patrick, would you like to make your final comments?
Yes. Thanks, Madam Chair. Thank you to the committee members, to the technocrats from the ministry. Thank you very much for providing us with the opportunity as we continue to advocate for the rights and concerns of people living with HIV, especially women who are mostly victims of sexual harassment.
Thank you. Thank you so much. I think we had a very spirited discussion, a very fruitful discussion. Thank you so much, Ms. Shields, Mr. Patrick. You're free to take your leave now. Thank you. So members, we just have a little housekeeping to do here. Have to recommit the minutes and to ask for confirmation of the minutes if there are no corrections. Thank you, Senator Morrison.
Second, Chair.
Thank you, Senator Gale. Matters arising? Okay, if there are no matters arising, I will move on to speak about any other business. All right, I would like to now use the opportunity to indicate that outstanding presentations are to come from Hugh Shearer Labor Studies Institute, Institute for Gender and Development Studies, combined presentation from the Jamaica Chamber of Commerce and the Jamaica Bar Association, and a presentation from the Jamaica Coalition for a Healthy Society. Those are the outstanding presentations which we'll schedule. The date of our next meeting, because as we had committed before COVID, that we want to move expeditiously, so we would meet every week. I'm really impressed with the turnout we have here today, and I know it will continue. So I'm proposing that the next meeting be June 25. We have confirmed that the committee can meet on that date because of the availability of the space. We also have a proposal for July 2, when we would have our follow-up meeting. Those are dates that we have to capture. If not, we may not be able to get Thursday. In the afternoon. The mornings, are the mornings available? Oh, the Senate? Yes. But, Member Daly, I think for this purpose, you, yes, can adjust your, because we really want to see you at the meetings. Yes. Yeah. So we're going to ask you to just adjust your schedule a bit for this purpose.
Of the members here. Each week when we come to Parliament, I throw a kiss at Babsy. Is it harassment? I want to know.
It depends how I receive it.
And I throw one at Favor and she catch it and put it in her bosom.
If you throw a kiss at me,
I want to know, because I don't want anybody to feel I'm offended. I almost got myself in trouble once because I was defending someone who was being harassed badly and brutalized physically too, and I also got myself in trouble, serious trouble too. And then the same person migrated, filed for the same sexual harasser, and they live in New York together right now. That is what Ms. Shields was here to hear. But these are the things that you have to be so careful. I almost committed a crime, serious crime, when I saw what was happening. And somebody just held on to me, and we took the friend into our home, thought we had hidden her from the man that was went to our workplace and abused her like many occasions. She went off, and then it happened that we were out. She was just afraid of staying home so long.
Well, sensitization, public education is going to be critical. It's going to be critical, and we have started the work through the Bureau. Yes, and I'm really happy to see how the members are keen on ensuring that we meet, that we have really very involved discussions here with the presenters. And those who are to be scheduled, I'm really looking forward to those discussions as well. And for us to, a matrix will be prepared where we can look at all the presentations and make a determination. We may even have to go into a retreat just to, within the parliamentary group, the Joint Select Committee, that we really look at everything and expeditiously move forward. I really want to thank the technical team. They're always here. Thank you so much for your presentation. And I guess at this point, if there is no other comment, thank you so much, Meeting adjourned. Thank you so much for coming. Bye.